Welcome to this meeting of the Canadian Unitarians for Social Justice. This meeting will be recorded and note opinions expressed by contributors are not necessarily those of the CSJ nor endorsed. Today's meeting, October 18, 2025, features demanding just care. Fighting government's medical and social abuse of disabled children and their families, moderated by Brad Evoy. Our next 2025 Let's Connect meeting will be November 15. What happened to UU social justice? Keep an eye on it on the Just News Express. For more info, subscribe at csj.org and menu option Just News. We welcome any suggestions for topics and speakers. Let us know, cusjmedia@gmail.com. And today's team of co-hosts are members of the CSJ board and the panel. And my name is Ellen Papenburg and I'm your host. We have room for more members on our team of the CSJ board. Contact csjmedia@gmail.com. So traditional Unitarian chalice lighting. Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has. By Margaret Mead. In the series Let's Connect UU Social Justice, we have a panel of 6 with as moderator Brad Evoy. Demanding just care. Fighting government's medical and social abuse of disabled children and their families. Brad is a member of the Kwalipu Mi'kmaq Nation, originally from so-called Western Newfoundland. He serves as the Executive Director of Disability Justice Network of Ontario and co-chair of Accessible Housing Network. DJNO is a provincial organization centered in so-called Hamilton, Ontario, that aims to build a just and accessible Ontario, hold the powerful to account, and create a world where disabled people are free to be. Brad will take it from here. And check www.djnoca. But then, a short part of the recording went wrong, so we inserted some information. Next speaker is panelist Angela Richard. She speaks about 24-year-old daughter E, who lives in a group home. Having both physical and developmental disabilities, E requires 24/7 support. Due to some unfortunate circumstances, Angela would like to remove her daughter from agency care, but if successful, she has nowhere for her daughter to go. Affordable and accessible housing are crucial for E. So here is a compelling story.
And my support circle 4 years ago was dwindling. My father had passed away, my mom had had a stroke, and I found myself being a caregiver for others besides just my daughter. So my whole support circle was dwindling. The group home agency that we approached promised us many things. We discussed our non-negotiables and the things that my daughter required for her to live a very full and happy life. And they didn't just agree to them, they signed a contract. I even had to sell them our home in order to make sure that my daughter had a safe and accessible place to live. It was a habitat house built with her accessibility needs in mind. But they didn't deliver on those promises. So, in fact, they denied Eugenie certain supports and services they had committed to provide. And her quality of life has suffered in more ways than I can describe in 5 minutes. There's been constant staff turnover. Some staff stay only a few weeks. The people who care for my daughter change so often that there's no consistency, no trust, and no opportunity for real understanding of her needs. And because I kept advocating for Eugenie, I kept asking questions, raising concerns, insisting that her rights be observed. I've been now banned from speaking directly with the frontline staff who work one-on-one with my nonverbal daughter. I'm not allowed to speak with them. They're not allowed to speak to me. And I now have visitation restrictions from visiting my daughter in her home. I'm required to give 2 days notice before I can stop by and say hello to her. So imagine being told that you can't freely communicate with your child whenever you like. She is nonverbal, so she requires assistance from staff to be able to do that. The agency also implemented a so-called zero lift policy, which meant staff were no longer able to support Eugenie's physical needs or physical therapy. She used to get daily physical activities, exercise and movement when she was with me. These are things that are very critical to her comfort, her health, and her happiness. Now she's lucky if she gets 1 or 2 short sessions a week. Leaving the group home isn't as easy as it sounds. The number one barrier is funding. Our provincial system only funds agencies, not families, for full-time care. I can't provide the 24/7 support that my daughter needs all by myself. And the second barrier is housing, because we need the 3 A's. We need affordable, we need accessible, and we need available year-round. And we live in a tourist area where rents are high and most affordable options are seasonal. So finding housing that's accessible on top of that is almost impossible. And sadly, we did have a home that checked all 3 boxes until we had to sell it to the group home agency. So if I could make one policy change suggestion, it would be to give families the option of direct funding so that we as parents or caregivers can manage our loved ones' supports directly. With direct funding, I could hire and train consistent staff who understand my daughter to help her choose where she lives and make sure her days are filled with meaning and not isolation. I'm not asking for charity. I'm asking for choice, for justice, and for accountability. My daughter deserves to be cared for by people who know her, love her, and stay. She deserves to move, to laugh, and live a full life. She deserves to thrive rather than simply survive. And that shouldn't depend on who's on shift or whether I'm allowed in the door. Justice for disabled children starts by listening to their families who know them best.
Thank you so much, Angela. I deeply, deeply appreciate your words here, friend. And I'm going to pass things now to Carolyn for a similar question. For yourself, Carolyn, can you tell me a little bit about your lived experience here? And similarly, what is one like policy recommendation that you'd want to bring forward to folks here together?
Thanks, Brad. My daughter is 35 years old and she's lived in a congregate care setting since she was 21. It wasn't a decision I wanted to make, but I was told over and over again it was in her best interest, that I wasn't going to be around forever, and that she needed to be independent of me. My daughter is a lovely, lovely girl. She's very well liked by everybody, but she's also very medically fragile. She's nonverbal. She depends on others for every aspect of her care. My issue with the agency was gender-based care. And I just want to share just a couple statistics with you before I go into, my experiences. Women with intellectual and developmental disabilities face significantly increased risks of gender-based violence. Research shows that over 40% of women with intellectual disabilities are sexually assaulted in their lifetime, often by people entrusted to care for them. Nonverbal women, like my daughter, are even at a greater risk because they cannot easily report the abuse. Women are 5 times more likely than men to experience sexual assault. According to a recent US study, 99% of perpetrators of sexual violence are men. Many organizations have recognized these risks and adopted policies to reduce them, such as prohibiting solo staffing, implementing same gender care for intimate support, and conducting unannounced inspections, and in some cases have adopted video surveillance. Unfortunately, the organization where my daughter resides has not engaged in these risk reduction strategies. Instead, my concerns regarding my daughter's personal safety and care were minimized. Over the years, I made it very clear to the organization at every level that I do not consent to male staff providing intimate care with my daughter. 3 years ago, I learned after the fact that a male had been assigned to overnight solo shifts and had been providing personal intimate care to my daughter for 3 months without my knowledge. I was devastated. I immediately brought my concerns to management, and to their credit, the male staff was removed quickly and replaced with a female caregiver for the overnight solo shifts. I was told by a manager that they get the impression that I think all men are predators. I found this comment to be insulting and condescending. I have never opposed male staff in general. I value diverse caregiving, and I believe it benefits all. Disabled people have the right to consent. Staffing shortages and budgets do not erase that right and are not justifiable reasons to deny a person's care needs. When organizations care for vulnerable people, their first and highest responsibility is to keep them safe. That duty must guide everyone from frontline workers to executive leadership. At the time, I sat on the board of directors and brought this concern forward. While the board agreed that my daughter has the right to decline care from a male caregiver, they refused to revise the overall policy. Instead, they told me that a male staff would only be used for overnight solo shifts on very rare occasions. That promise was not kept. In 2023 alone, the designated female overnight staff called in sick 96 times, where male staffs covered that shift over 25 times. Despite my repeated concerns and proposed alternatives, in 2024, males staffed the home on solo overnight shifts 22 times. I raised this with management again and offered several workarounds, and which many of those workarounds have been used in the past, up to about 5 years ago. But I was told none were possible. My husband and I filed a complaint, and we were told that the organization does not share our concerns and would not consider gender-based care provisions. Not long after, the organization shifted from the open to closed membership, removing the voices of family like ours from governance. So as it stands now, when a male staff works solo overnight, my daughter must remain in her soiled pull-up until a female staff arrives in the morning. If she vomits in the night, she lies in it until a female staff comes in the morning to clean her up. This could be up to 8 hours. This is inhumane. It violates her right to cleanliness, safety, and dignity. On October 7th, just a couple weeks ago, my daughter woke up early in the morning, soiled all over her bed. They even had to throw out her comforter. So the male staff that was there solo overnight redirected her to the washroom at about 6:30 in the morning. She had to sit in her feces until 7 o'clock until a female staff came in to clean her up. Again, I brought my concerns up to the management, and it was insinuated that it was my fault. And I was told that if Rochelle chose not to exercise her right to choose her caregiver, she would have appropriate care available to her. I want to emphasize that I've always been a longtime supporter of this organization. I sat on the board for 3 years. My concerns have always been expressed respectfully. I've never yelled at staff. I've never raised my voice to anybody. But now, because I continue advocating for my daughter's human rights, I've been labeled as belligerent and threatened with a no trespass order. The organization even told me that they would begin the process of disengaging with my daughter unless I signed off on the complaint and agreed not to raise the issue of gender-based care ever again. Ever again. I could not in good conscience do that. She is still not receiving the care she needs and deserves. We just can't wait until tragedy happens. I just want to quote something from Article 16.1 of the United Nations Convention on the Rights of Persons with Disabilities. Parties shall take all appropriate measures to protect persons with disabilities from all forms of exploitation, violence, and abuse, including their gender-based aspects. This just isn't a policy, it's a human rights obligation. Brad, you asked if I could make one policy change based on my experience. It would be that no solo male staff overnight with nonverbal women or all vulnerable women, period. Thank you.
Thank you, Carolyn. I very much appreciate that. And I think that, the thing that comes to my mind too is that, what you're describing is very much based in gender-based care. But I'd also say to folks too that, broader culturally appropriate care and a lot of these pieces for different communities, in particular for, racialized communities and for other communities as well, there's similar stories that we hear as well. So, what Carolyn is bringing to you here echoes across the system in so many different ways. And we so deeply appreciate, your story here, Carolyn. Thank you so much, friend.
Thank you.
With that, friends, I'm going to pass things to Barbara. If you could, Barbara, relate this to things that are happening in the broader child welfare system, to recontextualize some of those pieces in there, and building from those examples, dig into that system in relation to where we're going today.
Yes, hello everybody. So I would like to speak briefly about our personal case and then a bit more generally about what's happening. So do you see the screen I shared?
Yes.
Yes, okay. So this is our family in between 2017, 2021. And as Brad had already said, our son, who was 8 weeks old at that time, had several strokes and had a respiratory arrest, which ended up in him having developmental disabilities now that he's 8 years old. Instead of getting care for him, like medical care and support further on, our family was instead labeled as child abusers for no other reason other than we had no explanation for his injuries, for his brain bleed, right? The clots that caused his strokes were very clear in the MRI that was done on the night that he and his siblings were apprehended in 2017. And there was absolutely no reason to think that we would abuse any child, let alone our own child. We had zero history of any such problems. We were a completely non-problematic family. So this resulted in harassment from CAS Waterloo and Hamilton for 3 years altogether, and also resulted into criminal charges against my husband, who was the last caretaker of our son at that time. So here, this was our first family picture in 2017 with our little babies. This was the next picture we were able to take as a family of 5. After being separated for over 3 years. So when this ordeal was over for us in 2021, I started a federal nonprofit because throughout the years that we were fighting this, I learned that we are far from the only ones who are going through this. in Ontario and in Canada overall. And I started connecting with these families with closed cases where it was proven beyond any doubt that the reasons for the apprehensions of their children was medical and not abuse. There is a whole list of medical conditions that are commonly misdiagnosed as abuse. As you can see, those are at least 3 big groups. This is not my list, it's taken from a medical article that you can look up yourself. And a lot of these issues are either connected to various conditions that show as bruising in a young child who is not mobile. Then there's a huge group of unexplained fractures, usually various fractures in various stages of healing. And that does not present as fracturing that you would, you or I would fracture. So it doesn't show as bruising, swelling, any of these things. These are usually conditions that are connected to weak bones that the parents have no idea that the child has. And when these fractures are shown on an X-ray, they're automatically labeled abusers and the child gets apprehended. The third big group are conditions where my son would belong to, anything that is brain related, and a lot of these conditions are labeled initially as shaken baby syndrome. There's another huge group that we see again and again are children with complex medical conditions, and also children who, for whatever reason, fail to thrive. And again, before any second medical opinions are obtained, without there being a complex research into what the child is going through, the parents get labeled as the ones causing it, in this case as Munchausen by proxy, fabricated illnesses, and the child gets taken. So we see again and again, and this is related to our group's topic, that families with children who are non-verbal, either because of age, young babies, or abilities, people with developmental disabilities, go through these ordeals quite a lot more than other children who can say their side of the story. We see a lot of these problems with children who have complex conditions or rare medical conditions for obvious reasons. And also there's a huge group of families who simply cannot afford the legal help that they would need, because these cases are not a case that takes days to weeks. This takes, if you are lucky, months or years. In our case, this all took 3 years, as I said. We were lucky that we could afford the legal help and second medical opinions from independent doctors. And this cost us over $300,000. So you can imagine that not everyone is able to defend themselves in these kinds of situations. And it, like the fact that your child is taken when they are sick, you should not be put into that position when you are at your lowest, because you already are so scared for their well-being. So what we are trying to do as a nonprofit is we have petitions open now for signing. We have a petition in Ontario, and we have a federal petition. I will put the links into the chat below. And what we are asking in these 2 petitions is basically that all families are able to get second medical opinions for their child before the child is apprehended. This will not help anybody who actually abused their child, because obviously this comes with a caveat. Some people do abuse their children, there's no doubt. But having a doctor who can look into the child's x-rays, imaging, with medical documents, does not help any abuser. But it helps very much parents whose child is actually sick. What happens in these cases is that once the child is apprehended, which is immediately in most cases the same night or the same day, the parents are automatically cut from having access to their child's medical records and imaging. So when the case actually is heard by a judge for the first time, so within 4 days in Ontario, the parents have absolutely no way to have any evidence on their side that they did not do any harm, because it's on them to prove that they did not abuse the child at that point. If you have no access to the child's medical records or imaging, you cannot request second medical opinions. Your hands are completely tied in these cases. And it usually takes months, again, of legal proceedings to get through court access to your child's medical records and start to dig into what could have happened to them medically from independent doctors. Another problem is that, it is increasingly difficult to get an independent opinion from doctors on these cases in Canada. And many families have to reach to doctors in the USA who are just not connected to the system here and are not afraid to be prosecuted by their peers, because doctors do get prosecuted and get labeled as, fighting for child abusers and so on, even though, again, these cases are again and again proven to be medical issues. So that's number one. We call for mandatory second medical opinions. We call for increased oversight in these cases because there are zero official statistics of how many children go through this, how many families go through this. Neither the hospitals, nor CS agencies, nor Health Canada, nobody in Canada is obligated to keep track of these cases. So we have no official statistics. We just have statistics from people that we keep hearing from with closed cases where this is proven. And lastly, we call for official or increased oversight for the child abuse pediatricians who are connected to the child protection agencies who do this to the parents. The federal petition is very much similar to this. Again, we call for mandatory opinions, second mandatory opinions, oversight, and tracking of these cases. I welcome any questions if anybody has any questions, and I'll post the links. Please consider reading these petitions and supporting. And one more thing that I would like to show you, there's some resources where you can learn more about this. In January this year, Toronto Star published an investigation with, I think it was 10 closed cases where it was proven that the child was initially acutely sick, misdiagnosed as child abuse victim, apprehended, and the family was prosecuted. So our case, other examples of this. And it is a very well written article or investigation. It's quite long, like 19 pages long, but you will get a good oversight of this issue from an independent source, very well researched. I will post the link in the chat as well, and I encourage everybody to be informed. The reason why you might not have heard of this yet is multiple. There are a lot of gag orders in these cases against families in the name of child protection or in the name of protection of the identities of the children who went through this, which the only entities it protects really are the ones who did it to the parents. Also, there's a lot of shame connected to this, as you can imagine. If you are labeled as a child abuser, sometimes that label sticks, even though you won all the all the trials that there are. And sometimes the families just want to, make a thick line when the case is over and just go on and forget. So yeah, again, I encourage everybody to read this, to have an idea what's going on, and please consider supporting our petitions. Thank you.
Thank you so much, Barbara. And I think that your very clear policy suggestions here is a really good segue to talk about another set of very clear policy broad suggestions from our friend Maria with access to seniors and disability. And so Maria, you know, your work has been very focused around the property or the Trespass to Property Act. And so could you tell us, what does the Trespass to Property Act look like in relation to what we've talked about today?
Yes, thank you, Brad. What it looks like is a weapon. The Trespass to Property Act is weaponized and used against family members, friends who advocate on behalf of their medically ill, medically complex ill, disabled children that are living or adults living in group homes. And unfortunately, it's a way of gagging the advocate, scaring the advocate, and silencing others in that home. So if you, let's say, have been threatened with trespass and they find out, you know, Angela, Carolyn, whatever, you know, she's a really strong advocate, but look what happened. You then silence yourself. You're no longer raising issues. You're too scared of having the same issue happen. And this happens in group homes and senior homes a lot. And in senior homes, it has this other edge to it. Whereas, let's say the daughter or son of a senior gets trespassed, that senior then will never complain about abuse or any wrongdoing again, because they're afraid that they're going to hurt their daughter, their son. So it's actually like I say, a weapon, and it silences and it creates protections against abuse in these homes, because in the seniors' cases, they're too afraid to talk about it in case their kids get trespassed or their family or friends. And in the case of group homes, the other mothers and fathers are terrified as well. And what I don't like is that, at least in some cases with seniors, depending on the level of disability, cognitive dysfunction, they'll say something, maybe they'll whisper it somewhere. But you know, in your cases, these people are nonverbal, and who knows what's going on when they find out that their mother isn't seeing them as often as she used to, or their father, whatever. Usually it's the mother. We don't know the distress they're going through. In my case, when I was trespassed, yes, my mother was early stages of dementia, but she still could verbalize and put her thoughts together. She was traumatized, and I've heard many other mothers, or seniors, that have been traumatized. At least they can verbalize it. What really bothers me and irks me is that disabled children and disabled adults that are nonverbal or limited verbal ability, they can't discuss their trauma. How do we know what's going on? We can't even, bring it forward in terms of a police case. It's very, very difficult unless you have a lot of money. Like we just realized, heard $300,000, seriously? Anyway, but the act itself is perfectly written. It's very well adjudicated. If used properly, it protects the resident, the person living in the facility. That's all that it's about. It's about the physical possession occupier. And these homes have zero authority to be able to use the Trespass to Property Act like they are. A situation now that's emerging that's really, really scaring me, has me quite concerned, is the Ontario Patient Ombudsman. He is going to offer at a long-term care conference on October 27th in Toronto. He is going to offer long-term care facilities a fair way to trespass. In other words, he's come up with some concept where, it can be fairly done. Well, unfortunately, there's none of this type of thing in our judicial system. And by the way, if there was a fair way to do it, then our judicial system is the one that puts it forward, not a government state actor who doesn't really understand the act either. And so what concerns me here is, one, it's going to open up a Pandora's box. And I'm quoting a detective who does, police detective that does investigations into seniors abuse. And so the homes will now say, yeehaw, you know, all the work that has been done with Motion 129, Boulah's Law, or any of the other work that has happened, they're going to say, oh, great, now we get to trespass. There's going to be collateral damage and lateral damage, and the lateral damage is group homes. Because the Ontario Patient Ombudsman speaks for Ontario. And so what will happen is that group homes will also be targeted as a place where they can now adopt the Ontario Patient Ombudsman fairness by design trespassing. And this is going to potentially be a huge issue, because right now, the strides that we've made, okay, the Ontario Solicitor General is training, all police colleges are being properly trained on the Trespass to Property Act. They now know to go into a facility and say, who wants to issue a trespass? And if it's a facility operator, they're going to say, no, no, not you. Where is the physical possession occupier? In other words, where's the resident? And if there isn't a resident that's issuing a trespass, they're going to say, okay, you want to remove that person? Well, if you're saying that they're threatening or being, you know, extremely disruptive, here's your options, but you can't trespass them. Whereas the Ontario Patient Ombudsman is going to remove all that and allow the facility operator to be judge, jury, and executioner of your behavior. And yet our courts have said being belligerent, being loud, being obnoxious, using colorful expletives, being agitated or aggressive are not grounds for trespass. And in a case that I quote often, the Carr versus Ottawa Police Services Board, the judge said, just because you're that way doesn't mean you're on the precipice of committing an assault. Whereas these people say, oh, I'm scared, I'm scared. And staff have caught on to to say this now, I'm scared, I'm scared. Well, you know what? That's how you feel. But the law isn't about how you feel. What has happened? What is the action? Have you been hurt or you know, slammed against a wall or slapped? Anyway, so that's the biggest drive right now, is to try and get the Ontario Patient Ombudsman just to withdraw his seminar until he becomes more educated on the Trespass to Property Act. And so a recent letter, I've been working with Lise Bourgeois now for quite a few years. We drafted a letter and basically said to contact LEAPS. It's a law enforcement agency protecting partners protecting seniors. Detectives Martin Franson and I have corresponded over the years, and we are on the exact same page. And so I thought, okay, you know, on behalf of Access and Seniors Disabled, I've written to the Ontario Patient Ombudsman, Lise Bourgeois has. I reached out to LEAPS and said, would you be willing to speak to the Ontario Patient Ombudsman? I mean, for God's sakes, you're a police officer. You're training other police officers to know how to use the Trespass to Property Act and to go in and literally bypass facility operators. He said yes. So now we're begging, and I mean begging, the Ontario Patient Ombudsman to call the detective. You don't want to listen to me. That's fine. I get it. You know, what am I? You don't want to listen to an MPP. That really has me concerned. But I want to see him talk to police officer, because at the end of the day, if he goes through with his intended seminar, he is actually breaching on behalf of the government the charter rights of anyone who's been trespassed after he does this presentation, because he's encouraging them breaking the law and violating charter rights.
Mhm.
Thank you so much
And
for
that's
that,
it.
Maria. Oh, go ahead.
And we're trying to disarm it.
Thank you so much for that, Maria. I think that really lays out clearly the specifics on the Trespass to Property Act and how the state pulls these things together. But ultimately, and I think this is where we're going to pass it over to Megan. All of these pieces kind of fit together in a broader structure of institutionalization, of carceral violence, of these sorts of pieces. So, Megan, I'd like to ask you, how, in your view, do all of these pieces fit together in terms of issues of institutionalization.
Yeah, thank you so much. So I think that we've seen a lot of different forms of violences, of harms within the presentation today, ranging from the experiences of children who are stolen from their parents and apprehended in incredibly violent ways, all the way to seniors who are abandoned from and cut off and isolated from their families in also very dangerous ways. And so I think like what we can recognize is that there's this massive pattern and reliance on these forms of um, quote unquote care that remove people from our families, remove people where from the care that they actually need, and place them in spaces and sites that are really dangerous, that do things like, as Carolyn dictated or shared, like leaving someone in like in a spoiled bed for hours. Like that is so dangerous and violent. And so I think when we understand it through all of the stories together, what we're seeing is a really, really fundamentally horrific system that we have to stop understanding as normal and as just another day in these lives. And I think with like families, but when we speak to families, it is some of the most horrifying stories that you can ever hear that you just keep hearing, and they can't, it's difficult to normalize them because of how shocking they are. But sometimes I find myself at the end of the week being like, wow, that was just a week. But then you look back and you're like, we are talking about a child being taken from their family and being left. And that is like the worst violence. And so I think when we're looking at this from a systemic level, what we see is those larger actors who are responsible for the care, like the group home agencies and like the agencies who run the group home agencies and the ministries that fund those agencies, is that they are not accountable to citizens. They are not accountable to us. They are not accountable to me as a disabled person who requires care. And so we need to instead begin this process of building a new system, of finding ways and really pushing forward that advocacy that we started hearing about at the beginning with Angela, of needing direct funding that is 24 hours, that focuses on the joy and laughter and love that people have. Because like when you hear all of these stories, it can be so, I think I often struggle with processing them because um I think it can orient people towards only harm, but like Eugenie's laughter and joy is like a feeling that I cannot like, um, I will do anything for that laughter and joy and play. And all of us should fight so hard for that and like find ways to continue supporting each other, because at the end of the day, like we are in a world that's really challenging right now, like we are talking about you folks with the Unitarians for Social Justice really span lots of movements, and you see that there's so much harm. And part of the ways that I think disability really adds to this is that joy and laughter and care and love of life that like is fundamental to so much disabled life and so many people. And is like, it is worse for me not being able, um, yeah, sorry, I'm gonna keep going, but I just saw John's comment. But there's so much that we add to communities when disabled people are part of them. And there's so much to fight for when we are thinking about building these new worlds working together to imagine new ways of being. And I think like a huge part of that is finding ways to access the care that we need, that is just, that is joyful, that is celebratory, that is like well paid and well worth people being supported through their lives. And so I think as we continue to reconcile with both the past and the histories of institutionalization, just recently, sorry, just to go um, back in time a little bit, just recently there was finally a disabled child who was institutionalized through the residential school system, Percy um, Onabogawin. Maybe we can share the link in the chat. And he was stolen from his family, just as we hear today through the child welfare system. He was an Indigenous child who was placed into residential schools, and through the disabling process of the residential school system, he was then placed in another disability institution. And we see this process over and over again. And in the past, like he died and was buried on the lands of the institution. And that is such a shame. And I think one of the things we struggle with is that we are both reconciling with the violent histories of institutionalization and fighting with the present horrors that we have talked about today. And also, I started kind of with the joy because that is the thing that keeps us going, where we can continue to build these new worlds, fight for these new worlds, and have places where everyone is valued in their wholeness, in their light, and in their like laughter and joy and sadness. And um, disability looks really different. And the ways in which we are currently institutionalizing, abandoning, kidnapping people, that will cause fundamental harms that will continue to resonate in people for lifetimes and will continue to justify institutionalization because they are so disabling. And so I think it's really important that we come together and that we like with the light that we have, in the chalice, that we use that to keep going and to keep holding on to the life that we get to bring into all of these worlds. And it's yeah, right there.
Thanks so much, Megan. And I guess just to before we open up to questions, I want people to hold on to something here, right? The systems that Megan, Angela, Carolyn, Deborah, Maria, and our whole team have talked about here are all fundamentally interrelated and fundamentally interrelated to broader systems in our society, right? When we look at the treatment of so many in our society, it comes back to the same violent principles that you see in these supposed systems of care. And so I think that when we have the moment to bring some of these ideas together and bring together our understanding of these systems, we really look at how we can understand not just bringing just care in like for group home residents or for folks in any of these specific systems, but how care should operate in our wider society, and really looking at what we need to truly look at the underpinnings of what brings these things together. As we mentioned, as Megan mentioned, and as I mentioned at the start, these are ideas that have been embedded in the Canadian system from jump, right? This is part of the foundation of this society. And so having opportunities to challenge that and bring things together and have moments to talk about it with all of you is incredibly, incredibly important. And so I want to open the floor to questions. We'll start with the first one we have in the chat, which is from John. And so he's a bit confused about the Trespass to Property Act and asked the question, is the concern that the act would allow abusive or neglectful PSWs to prevent angry parents or relatives from visiting or complaining? If someone is banned from visiting, could the act mandate a closed circuit camera in the patient's room? So I'll pass that to whomever from the panel would like to take an initial shot with that. I have a feeling, Maria, you have some thoughts on that. And I'll open it to the floor.
Yeah, I'm sorry, I didn't catch the entire question. Sorry, can you repeat it? Is that okay?
Yeah. So is the concern that the act would allow abusive or neglectful PSWs to prevent angry parents / relatives from visiting or complaining? And then the second question, if someone was banned from visiting, could the act mandate a closed circuit camera in the patient's room?
Okay, the second one's an easy one. No. The Trespass to Property Act is simply about possessory rights of property. The research I've done has gone way back to the feudal times, and the act came about in order that you get to, as a occupier, it doesn't matter whether you own it as a deed possessor or you occupy it as an occupier, it's about protecting your rights on your property, about you having possessory rights. And the sole thing is who comes and goes. That's it. That's all the Trespass to Property Act does, is that it gives you the right to say who comes and goes. So now the act being misused by angry PSWs, frustrated PSWs, yes, they don't have the right to use it though. Only the occupier, the physical possession occupier, has the right. So when a PSW bans anybody, they don't have the authority. And they also, being angry, or if you're angry or frustrated, it's not grounds for trespass. We have court rulings on that. So that's basically it in a nutshell. It's I get that PSWs get angry and frustrated, and they're overworked and they're tired. And then, you come in and you're agitated because you found your loved one sitting in what for, 6 hours or whatever. You know what? That's part of the job, and expect that when people come in and see human indignities, that there may be an emotional outburst. And so far, an emotional outburst has not been codified as something that can be charged. Now, for putting camera, by the way, you're allowed to put a camera in. There's no law that says you can't. They've tried stopping in long-term care homes, but they can't. It's you're entitled to have a camera in at any time to observe your loved one. And why would you want one if you got banned? You're not supposed to be banned. Get in there.
They don't allow cameras in group homes.
Mm-hmm.
But under what authority? They can say that. What's the authority? Where's the law?
Their own. That's it.
Their own, yeah.
No.
Intimidate.
I don't care. Sorry, it's not. I don't care. The system doesn't care. The judicial system doesn't care. You have the right to put a camera in your like in long-term care homes when they try and fight it, or retirement homes. There's no law that says you can't. Therefore, until there's a law that says you can't, you can and say that it's for the protection and that you want to observe your child. You want to be able to connect at any time with your child or your senior and just watch their daily, whatever. The home's saying you can't, they have to have legal authority, just like they have to have legal authority to ban you, and they don't. You have to be very careful when they say no. Ask them for the legal authority. And this is something that Police Detective Sergeant Martin and I were discussing for hours the other night when we read over some of the OPO stuff, and we're saying, where's the legal authority? He can't just make it up.
And I would just add on to this question too, because I think that one of the things, and this is kind of a different kind of part to that, is like a lot of the issues that we run into, and I would say, when it comes down to it, it's not in the end, there might be a frustration with a given worker or what have you, or some reaction. But a lot of the times, like, the reality is that it's actually the management of the group home that has the biggest issue, right? Like, we have seen cases where it's group home management, it's group home leadership, it's people who are working really hard to maintain the kind of working conditions that folks have and the living conditions that residents have, that are the root core problem of trying to enforce certain kinds of pieces together. So it's like, we can, there's a lot of folks who are in these systems who work really well with different families and who have a broader kind of good relationship with folks. I've heard lots of those kind of stories, but then saying the CEO or the director of this and that is the one who really had an ego trip or really wants to control how folks interact and what we do, and do the same things to their workers too. So and often to a lot of migrant workers in those spaces.
Yes, Brad. I mean, management is the number one problem that I've run into the most. There are actually PSWs that actually, I mean, there's very few PSWs that I have had cases of that actually get mad enough and say they have to ask management, first of all, to trespass. They can't, they generally don't do it their own. Management is the number one problem. And I've had cases where PSWs, especially after they've quit working for the facility, reach out and they'll say, you wouldn't believe what management did to that mother and that disabled child or adult, and how they trespass them and how could they. It is management. That's number one. You're absolutely correct.
Absolutely, friends. Absolutely. Do folks have any other thoughts on this question, friends, from other folks in the panel, or do folks have another question? I see a hand. Ellen.
Yes, I was wondering, is this only in Ontario, or is it Canada-wide?
Which, I'm sorry, is that question to me, the Trespass to Property Act?
Yes, basically, are they doing this all over the country? And yeah.
Yeah, every province has a Trespass to Property Act, every single province. And when people have reached out to me from Newfoundland or BC or Alberta, I do look into their Trespass to Property Act because everyone is written just that little bit different, but certain nuances can make a very big difference. So I have to know before I write a letter to the facility saying, I'm sorry, you can't do this. This is illegal. Your Trespass to Property Act doesn't permit it. So I have looked into them. At the end of the day, some of them will say owner or occupier, which means you're either the deed possessor, like you are in your own home. If you own, if you've got a mortgage and you're paying it, you've got a deed possession, then you're the owner, or you're the occupier, you're renting. Where those ones are, I find more is in Alberta, Saskatchewan, farmland areas. The Trespass to Property Act is still really written about farmland. But again, at the end of the day, the person that is even renting or occupying the land, they have the authority to say who comes and goes. So basically, although written differently in each province, at the end of the day, there's always that part about the occupier. The Ontario Trespass to Property Act is the clearest written. I love our act. And so my initial start out to this was because I'd heard from so many people across Canada. And actually, I've had people reach out to me from Australia, from Germany, from other countries. And I'm like, sorry, I can't do any research into yours because I got enough in my own country. I do try and give them a little bit of help, but it's like, I don't have time to read your act and then do all the case law research, because until you do case law research, any act can be written any way you want. The Legislative Assembly writes an act, they pass an act. The interpreters and the adjudicators of it are strictly our judiciary. So Ontario legislation could be written. Those words, the interpretation and administration, is with the judiciary. So I can read an act, but then I have to read the case law and say, how has the judges interpreted the words in this act and how have they administered. And it's a lot of work. So originally I thought I would do right across Canada. And then I realized just how much work it was just for Ontario. But I thought if I can make a change here in Ontario, where there's precedent cases and precedent situations, then you're more likely to have lateral effect. Like I know in Vancouver, everyone there, I've talked to police officers, and even while I was here working in Greece, there was a police officer, and he says, oh yeah, I'm from Vancouver. And I told him what I do, and he goes, your motion 129 Vula's law? And I said, yes, that's me. And I said, you've heard about it? He says, of course we've heard about it. And I thought, wasn't that interesting?
Wow.
Yeah, because I was, that was, but I was pleased. I was pleased. So there's a ripple effect sideways. But first, I have to focus on Ontario before I spread myself thinner across Canada. I thought if I can get something done here, it's solid, then it can move laterally. So I realized it's a step by step, because the resistance here by the government to observe the judiciary rulings is unbelievable.
Right. Thank you very much.
Yeah, thanks for that, Maria. I just wanted to quickly on this too. I don't know, Megan, if you'd want to jump in to talk about some of the national scope of some of the related systems to this too.
Yeah, totally. And like just to follow up, like so all group homes, you are a tenant, and the Landlord Tenancy Act means that for group homes you can actually be evicted within a day. And so I would be very like cautious about the cameras and those pieces, because the eviction policies are very fast and
All
dangerous.
right, Megan, are you saying the landlord and tenant board does not apply to group homes? Because
It
that's
does
a 30
apply.
day.
It
No one
does
can eviction
apply,
a
but
group home. They have
it
to apply
hasn't
first to the landlord and tenant board.
it has an expedited eviction process.
The landlord and tenant board for group
For
homes?
yeah.
Are you sure about that? There's no case law for that. And because I know of a case that happened here in Ontario in a group home, that's not what happened. And in several cases that I have fought with eviction, no, that doesn't happen. So I'm a little confused. Perhaps you can contact me, because I work on these evictions, and no, they have to apply to they have to file, they have to give
No, so
reason, the home
yeah,
has to
so
give a
there's
reason, and demonstrate accommodation unto undue hardship. And the landlord tenant board has ruled always in favor of, there's only one policy with policy, there's only one act with the landlord tenant board. So I'm curious. I'd love to hear more, Megan, if you can reach out to me.
yeah, I was about to say, like it, so the ways in which the Landlord Tenancy Act is written, it has provisions for certain types of group homes. And so there's lots of different types of group homes across the country and also across the province. And so one of the challenges with like all of the like reflecting on the system at large is that there's infinite different ways that institutionalization happens now, and who is operating funding responsible for it, and like the ways in which things are written and how laws are promised are evidently not what happens within our systems and at any level. And so, unfortunately, even though if something is written one way, the ways in which the system works is that rights will not be followed. And so it's a terrible process, but it is like how, unfortunately, group homes work. But I guess just to say that, like, across Canada, we've done a lot of research, and I'm part of a research group doing access to information requests for people who are for deaths and abuses in group homes. And we've seen across provinces that it is definitely a systemic issue that is happening in both group homes, but also within the long-term care home system. And also, like, we're seeing issues such as the institutionalization of children and young adults into long-term care across Canada, along with increased use of institutions for things like brain injuries and drug use. And so we're seeing really like this intensification of institutionalization, especially in this time of like when people talk about supportive housing. That's like we don't really have a lot of definitions about what that can look like. And that can be a very dangerous, very involved system.
So we've got a question in the chat. So how can we address the systemic double standard in which staff claims of feeling threatened by family advocates for nonverbal or otherwise vulnerable residents, including those who are also minor children, are taken seriously, while similar claims from families are dismissed, pathologized, or even criminalized? And there's a follow-up. In many cases, staff accusations lead to family advocates being labeled as disruptive, abusive, or even legally removed, while genuine reports of fear, mistreatment, or abuse from residents or families are minimized. How can this imbalance be effectively challenged and corrected, especially when it is reinforced and perpetuated within legal and judicial spaces that should instead be protecting the vulnerable? So I'll open up to our panel to take a shot at these two questions. They're very large questions for where we're at, for sure.
I'm in on that one. It doesn't matter what you're labeled. You could be labeled. The problem is that they have to provide evidence. So in a few cases where I've worked with mothers in group homes and also definitely with seniors, the first thing we ask for is for the evidence file. There should be dates, times, witness reports, and that sort of thing. And there was a case I worked on at Christmas, and the police officer was called in to trespass, and I wasn't able to be there physically. It was in Windsor. And so I said to the officer, well, you're right there. They're claiming that this guy's what? I said, great, get the file. Get the incident reports. And they didn't have anything. I said, that's exactly what I'm trying to say, is that right now they're claiming that this man has to be removed immediately because he's, hostile, whatever. And that he has been for, years. Where's that file? And by the way, if he is behaving that way, please remove him with disturbance and charge him with disturbance of the peace or mischief, because then evidence is required. They cannot charge you unless there's evidence. And there's never evidence. There's labels. The labels are flying around. But in order for anything to happen, they have to have evidence and then charge you accordingly. They can't ban you for labels. They can't, and they can't, well, first of all, they can't ban you because they're not allowed just on behavior. Our courts have definitely already ruled on that. But if you are definitely, you are aggressive or violent, yes, please remove that person if they are a true threat to the residents or staff. But do it with what is legal, disruption of the peace or mischief. Don't worry about labels without proof.
Appreciate that, Maria. Appreciate that. Do we have any other thoughts from members of the panel on this question, friends?
To back up what Maria said, I guess, the proof is in the pudding, so to speak, because any of us moms that have kids in group homes and speak up about it, we know that we get blamed for so many things, and yet there is no proof. But if we do not follow the rules laid out for us, we are afraid of further retaliation, further gaslighting, etc. So yes, it may be absolutely legal for us to put a camera in our child's room with no sound recording, just picture, but the staff will not like us for it, will be treated illy from the staff at the house because they will feel like their privacy has been invaded.
Hold on, sorry. That one I've got to chime in on. They are not entitled to privacy in your child's room. It is the tenant. The tenant is entitled to full privacy in that room. Anyone else in there is not. And this is something I've learned from lawyers. They've all said the same thing. This whole garbage thing about privacy. No, the only one entitled to privacy is the physical occupier of the room.
Totally,
So,
totally hear that, Maria.
Before I forget,
Totally hear
I'll
that.
mention that for you, so you have that backing yourself,
Yeah.
as backup information for yourself, because don't let.
Yeah, totally hear that, Maria. I'm just going to pass it back to Angela if you want to finish your thought there, friend.
Well, and I totally agree with you, Maria. It is absolutely legal to do so, but that doesn't mean that the staff at the home aren't going to react in a very negative manner, making life more difficult. And that the agency itself isn't going to retaliate. If I don't follow their rules of giving them enough notice, et cetera, then they can implement further restrictions upon me. Again, not legal, but they can make life very difficult. They can stop reporting to me. They can stop doing all kinds of things, and I will have no recourse. My only recourse is to take my daughter out of the home, but I cannot support her by myself. So they kind of have you between a rock and a hard place. They run the show and they know it, and they are all too powerful and they abuse that power, and that's what it all comes down to, is they put us in our place if we speak up and advocate too much. Oh, here's a good question from Barbara.
So what's the exact law that governs group homes?
This
I
is
can, yeah, this is the big question. But Megan, do you want to start with this one, and then we'll pass it to Joy, who has her hand raised.
yeah, I've spent like 5 years trying to answer this question. So I feel like now I have a pretty clear picture. And so there's a lot of laws that govern all of the different types of group homes. And so one of the complicated things about group homes is there's no one definition, and they mean a really large variety of things. Everything from like a children's care facility, all the way through to a domestic violence shelter, to a unhoused shelter, to a developmental disability home. And so there's a large spectrum of laws that are governing these group homes. And so some of the ones that we talk about here are the ones for adults labeled with developmental or intellectual disabilities. And those are part of what's called the social inclusion, or what is it? Social Inclusion for People with Developmental Disabilities Act, supporting services and supports for the social inclusion of people with developmental disabilities act. And then its subsequent has its own. And so that act governs who is going to be paid, because the province doesn't run group homes. They pay for group homes and they make the regulation. And so then it's this, chain of then going to the Developmental Service Agency. Those agencies are exempt from freedom of information requests. So they're a government, non-government agency. And then they then provide the funding from there to the group home. And then those group homes can have their own independent policy system, like within both the larger parent organization might have policies, and then the single group home might have its own policies. And then, even more, is that each individual in the group home has their own, what is either like a behavioral intervention, um, uh, like policy kind of like guide, or a support, what is it called? Like the um, service agreement. There we go. That's the one, of like what they're going to do. And so with all of those like different policies, rules, regulations, governance, there's kind of a lot of different systems happening. And so one of the big tasks that we always have is starting to is by beginning understanding from each case who is responsible and then trying to begin our advocacy from there. And really, I feel like now we have a much greater sense of like how the system is working and not. But the big thing is like the Ministry of Community, Children, and Social Services in basically every province runs these services, and is responsible for them. And then they have one law with like a bunch of regulations, and then everyone else, it's like the trickle down into a million different streams of regulations and policies and rules that mean like you can't go outside to smoke without being supervised with a support worker, or you only eat mac and cheese every day at 2 p.m. And yeah.
Thanks so much for that, Megan. And I would just add too, onto this point of these systems not being run by the respective provinces. We've got to remember that a lot of these systems are privatized. And for example, and I'm going to say his name because I talk about him every day. Mike Harris and his family owns a group home company. It is Extendicare and Paramed. If you deal with them, you are like Mike Harris is getting your money right now. And so the very people who broke the system 30 years ago and who continue to underfund the system, are the people who are making money off of it in Ontario and have ties to other companies around the country. But we'll pass it to Joy.
Thank you, everybody. Your information is so amazingly articulate and informed for us all. And as members of Canadian Unitarians for Social Justice, I'm sure we're all sitting here wondering, holy moly, what can we do? I thought I had heard some financial backing to continue your work, but any kind of advocacy sounds like a terrible maze. I belong to Amnesty International, and everything you're describing that is not working, it goes against the International Human Rights Commission on how everybody should be treated. And obviously, that's broken all over the place. I'm wondering if amnesty could be helpful, but then you're saying that the difficulties are within private ownership of what people get to do and don't do. I guess I'm lost. I want to help. I want our group to be helpful. Perhaps some people could articulate as best they can near our time to close. Is there something very meaningful that we as a group and individuals can do to be helpful? Thank you.
All right. Who on the floor would like to take the first shot at this? I see a raised hand with Megan, so we'll start there.
Yeah, I mean, I think one of the biggest supports that everyone can offer is supporting families who have kids with disabilities and showing up for them, and friends with disabilities, and showing up for them, providing them supports to make sure that they have like meals and a clean house and get to do fun things that they love and take an actual interest in their in like disabled people and our lives and like what makes us flourish. And I think one of the most meaningful things that I do is like work with people on the ground and just like getting to be there and show up for people. And I think that that is like a really important task, which sometimes requires like, looking out for people. But I think one of the things about like faith communities that's so important is that you can come together to provide support in a way that is really meaningful because there's opportunities to show up for each other. And so I think like, yeah, one of the big things is just like trying to really be be there for the people in your community, and then also really amplifying the messages of, I see you're in on the West Coast, Joy.
Yes.
Yeah, and so I know that there's lots of really amazing work happening over there. And actually, I think there was a really amazing presentation, or there's some really amazing stuff happening in BC around especially like palliative care laws.
Yeah.
And so I think there's like a lot of work to do to like amplify those messages and really just provide the supports for disabled people to live in community, because we can make it happen now if we show up for one another in real ways.
Thank you. Thank you. I have experienced a lot of situations where people who need care and are in homes or otherwise. I personally do what I can, but I certainly don't see any crossing the line of the care, and I'm sure it's happening. But I'm beginning to be a member of our seniors advocacy group in our Tri-Cities, and I'll bring the situation forward. And of course, my Amnesty International group that I mentioned. Yeah, I will personally take on the inquiry and do what I can with CUSJ as well. So thank you for all this, opening our minds to the horrible situation we face. It sounds like our Indigenous situation all over again. Yeah, yeah, and I wonder if this is just about greed. Greed.
Yes. Yes.
Yes. Yeah.
Follow the money. Follow the money.
Exactly, exactly. And I would say to that too, one of the things that you know, Megan has been doing, and also members of, you know, this group also, like, there's a lot of mapping of that kind of work and who owns what and what laws go, how all these laws and pieces interconnect, right? And you know, this is how you find folks like your Mike Harrises of the world who are profiting off of this kind of violence towards you know, our people, right? And I think when you bring up things around, you know, the broader residential school system and some of those pieces, you know, the continuity here between those elements is real, in part because these systems that we're talking about are also being used to extend the violence that are happening against Indigenous children too, right? Like when we talk about the child welfare system, when we talk about the broad kidnapping system that exists towards Indigenous children, right? You know, a lot of the things that you know, Barbara mentioned around the medical pieces, around medical kidnapping and abuse, a lot of the pieces around the you know, historic provincial asylum system here in Ontario, you know, all of these pieces also specifically affect Indigenous children disproportionately, racialized children, Black children as well. And so, you know, I think that, you know, we have to also see all of these things as like a deep interconnection with how, you know, that goes back to the founding of this country, right? I would also say too, and I'll let other folks jump in on this too, that in addition to, you know, some of the broad things that folks have mentioned, other actions folks can take. You know, I know Barbara has given some petitions in the comments. You know, there's also pieces from our group home brief, specific policy asks that we're pushing for. That would be really helpful for folks to take a look at. You know, and ultimately, you know, we need a lot of pressure on a lot of these systems and a lot of the people who run these systems to make it happen. And you know, that's fundamentally connected in with questions of like you know, Angela had mentioned around needing to push for you know, personalized, individualized funding, that, you know, Carolyn mentioned about needing to have access to care that reflects our needs, whether it's gender-based, whether it's, you know, culturally focused or what have you, you know, and, you know, throughout, you know, this conversation, when it comes to pieces that Barbara and Maria and Megan have raised, systems of accountability so that we can actually build things together. And so, you know, it's always good to put pressure on, you know, our broader political representatives, be they federal or provincial, to invest the time, money, and legislation to make these things happen. Because in the end, as we often say, the people who make the decisions here, they have names and addresses. The people who bring these things forward in terms of the greed and the capitalist exploitation that we're seeing from a lot of these companies. They have their companies, they have their AGMs, they have ways in which we can pressure them. And so, I really encourage folks to take up, the fight. And, I know that across our group here, we're all really, really happy to be able to share this with you, because it's like, this is something that all of us work on different aspects of. And, I really appreciate everyone for being here today. But I want to pass it to other folks on the panel before
Yes,
we wrap up. With this
but we are quite past our normal 2:30. But I can let it go if I see there's still a lot of people here. If you don't have any objection, we can go on to 3 o'clock. But then really we have to shut it down. Okay.
Absolutely, absolutely.
So I need to interject, people.
Thank you very much for the opportunity, but I have got another call that I've got to get on to. Thank you ever so much, Brad and Megan. This is fantastic work. The stories from the other women is just shocking. But yes, let's keep up the good work, and thank you very much for inviting me to the call.
Thanks, Maria.
It will be recorded, so it is recorded, so it will be on YouTube. So we'll send that. It will take about a week or so. Yeah.
I have to go as well. Thank you.
Yeah. And Joy needs to go.
I see somebody had the hand up, but disappeared again.
So I think the first hand I saw was from sorry?
I just need to go, and I've got the candle flame. So I'm going to put it out now. And you all know that when it leaves, the image is going to be the memory in our hearts, mind, and soul about our work ahead on this matter. Okay? And thank you for this whole understanding, all of you. So I'm going to withdraw. Thank you, Ellen, for hosting. And I can't wait to see your notes.
Yeah, thank you. Thank you, Joy.
Thank you. Okay, bye-bye, everyone.
Bye.
So I had seen Sherry's hand earlier, and then Sal.
Yeah, thank you, Brad. I just wanted to share that the concern I've been bringing to the federal government is that caregivers of children that are medically fragile, some of them with ICU level care, where a parent is required, generally it's the mother, to care for the child 24 hours a day. Some kids have seizures, they need suctioning, they have oxygen, they need nursing, but our government doesn't readily provide, sorry, Ashley's chatting here with me, the care that these families need. And the government expects you to be there dedicated and provide that care on air. There is no funding at a federal level for you to stay home for your lifetime to care for your child. So the EI benefits at a federal level exclude someone that has a pre-existing condition. So it could kick in if your child became ill at maybe at 5 years old, or you were in a car accident and you had to stay home, you could get, but if your child is born disabled and you need to care for them, you can't collect that. Which there's also many barriers to working if you need to care for your child throughout the day. Schools often cannot accommodate this child. Schools are lacking the resources and the supports and the EAs. Daycares are private and they don't have to accept your child. So at a federal level, and the maximum child disability benefit that you can get from the government is, and don't quote me, I think it's like $237 a month. If you're very low income, it's on a graduating scale. And so parents in Ontario, for instance, because that's where I am, that are raising a child And maybe if you're a single parent or you're low income, you'd be living on Ontario Works. So they're forcing these families into poverty. And when the families speak out for help, there really is no resources. So if you're lucky, you can get a bit of time from like home care if you're lucky. And beyond that, you're pushed into a hard place where you feel you have to choose to put your child in a group home, or even when they're finished schools, parents are forced to make that choice. Or do you want to eat or do you want to stay housed? So it's shameful, and I think it's by design. When they create policies, they're looking at two parent families, thinking that there's two parents, they should pay for their child regardless of whether that's a typical healthy child or a child with a severe disability. So that's my rant. And we, the Ontario Disability Coalition, put together a brief for the federal government, and we keep submitting it, asking them to look at all these issues. But it doesn't get a lot of attention. So thank you.
Thanks so much for that, Sherry. Sherry is also one of our collaborators on our group home brief, and a great pal who I'm so lucky to see, I think almost every week in a given month. So I'm always really appreciative of your thoughts on this, friend. But we'll pass it to another one of our collaborators, former co-chair of the Accessible Housing Network, Sal Amenta. Hey, Sal.
Hi, Brad. Thank you. I keep hearing all these horror stories. This is not news to me. And those of us who have been talking about real case studies, real people's lives, know that these things happen all too often. And I keep wondering, where are we going to find a champion journalist to take this up and paint graphic pictures of it in front of everyone so that they realize what's going on and what the government is permitting to happen and encouraging to happen? This is horrible. So we really need somebody. I'm not going to mention names, but we've seen it done before. A high-level journalist who will take this up for us.
Absolutely, absolutely. And I know we do have a journalist on the call, so just to flag that for folks, that I'm sure folks, if you'd like to speak with Megan Gilmore, now Megan has posted her email in the chat. All right, friends. Well, is there any further questions, folks? And then if not, we will call it a day.
Well, thank you so much, Brett, for taking over the lead on this, and it made it so much easier for me. And well, I'm so impressed with everybody stating what is going on, and it's really a horror. Also for seniors, I'm just dreading that we one day have to go into a home or something. I hope it will never happen, and we will just be carried out of our apartment here and not going to a home, because some homes might be okay, but I've heard too many problems with people. And thank you very much for bringing it all on. And I will share all the links in another mailing to you, and to also with a newsletter to the people that we have invited and people that couldn't come. Hopefully we can do something about the petition and so forth. So I will share just one more little screen here, some resources here. Of course, the WWDJNO for the Disability Justice Network of Ontario that Brett is very heavily involved with, and other people on the panel as well. And then the next CSJ meeting will be on November 15. What happened to the UU social action? Are we going to all die as committees? Are we gone dormant? There's a lot of things happening, rather not happening. So we will have a panel, and I will send out a very provocative email to the congregations and other members of Unitarians organizations, but everybody is welcome to come to this. So we will send out again a newsletter because you know we have a national organization, and we are trying to keep it alive, but somehow there is a lot of people that are not motivated anymore, and that is very sad. And I think it is totally unjust, especially now with everything that's going on down south from us, what is going on in the Middle East. And so we have to stay proactive. So cusj.org and cusj.org Just News are part of the website, and we have a forum that is quite active, especially on the Palestine issue and the Middle East, and all the mishap that has happened for. Oh, I'm sorry about this. That's my old clock. That is 113 years old. Anyway, and we are on YouTube, and we will send out you all the necessary things that we need to share with you. So thank you very much for coming here, and thank you for the ones here that could stay to hang in there. And let's hope that we can change the world after all a little bit. Actually, a little whole bit. And then I'm going to end the meeting, and thank you very much, everybody.
Thank you so much, everyone.